The first thing is the people. Obviously, this business is about the connections you make and the people you trust. And the most important people that I trust in this industry are at this company.
The new beginning. Other companies are doing things the same way they've always done them. And so having a new opportunity to do things a different way is what really intrigued me.
I'd say from a sales perspective, what I love most is that we have really the best of both worlds. So we're a big multi-billion-dollar international company with great financials, but on the other side, we also feel very much like the small little family-run company.
I like the safety of First American, but they've got a human side to them, you know, a little softer, gentler approach, and I really appreciate that, and they've really given me a great opportunity to go out and try and build something for them.
In Colorado, guess what? We're all local. There's 4 local underwriters, and together the other day we have almost 125 years of local underwriting experience in Colorado. And I tell that to people all the time, and that's really the big difference. We can make local decisions quickly to get that deal to the closing table. That's the big difference.
We're a team, and we support each other and look out for each other, and it really promotes more business for us.
First American is all about a work-life balance, and the leadership is incredible because they truly care about the customers or the associates that work here.
This is our customer service department, and the marketing support services that are just completely robust. Marketing is a challenge for a lot of real estate brokers. It's something they have to do, but it takes a lot of time. It can be expensive, and we have a fulfillment solution that is far and away better than anything else that our competitors have to offer.
The leadership is very down to earth, and they move very quickly. So anytime I've needed something or had to support a customer or had to make a decision that maybe cost the company money or whatever, they're very quick to make a decision on that stuff.
You're working with people who have been in this market, in the Colorado market, for 30 plus years. At one point, First American was underwriting almost 70% of all transactions in Colorado, and some of those very people were working on those files.
I really believe our people are passionate about our company and do it better.
Who wants more peas?
Go away.
Oh, Daddy hates pop-up ads.
Go away.
Hashtag dinner time.
Let's go forward.
Choose selfie. No! Selfie.
Let's go forward.
Delete selfie.
Go away.
Then picture.
Bookmark. Go away.
No, post photo.
Scroll up. Scroll forward.
Hashtag gravy.
Faster. Go faster.
The First Bank mobile app. Technology has never been so easy.
What if there was no car legal hotline? Just one call to a lawyer would cost you at least $250 per hour. What if you only had unreliable or hard to understand industry reports to include in your business plans and share with your consumers? What if there was not an organized association to fight for your right to conduct business in a fair and equitable manner and to protect consumers' private property rights? What if CAR never changes with the times to meet our members' needs? You don't have to ask what if anymore, because over the last 18 months, CAR expanded the legal hotline 2 more hours a week to help answer your legal questions. CAR created a research program that provides Colorado realtors with accurate and reliable quarterly housing market reports. CAR successfully advocates on Capitol Hill each year on behalf of all Colorado realtors and private property owners, so you can focus on your business. CAR created a professional development program that focuses on timely and relevant real estate issues through our live webcast program. CAR established relationships with many real estate-related companies to give you member discounts on things you actually use and need to be successful. CAR produced phenomenal networking and professional development opportunities in 2013 through its meetings and events. CAR's quest to make your state association better, stronger, more relevant, and able to withstand future challenges of the real estate industry is a never-ending journey. We have successfully put many solid processes, programs, and services in place. Now it's time to take the next steps of our journey by adding more value to your membership. Our vision is to create more opportunities for Colorado realtors to lower their risk by expanding the hours of the CAR Legal Hotline. Provide more reliable industry and consumer data to make you more confident and productive in the sales process. Produce even more live webcasts you can apply to your ever-changing business and help you remain on top of your game. Build a deeper political war chest to help preserve the industry and protect your consumers' rights. Increase our outreach to our local realtor associations, MLSs, and members. Take advantage of your CAR benefits and features. Visit coloradorealtors.com for details.
And with Uverse, you can move your TV anywhere in the house.
We're happy with Xfinity. Why would we move the TV?
I don't know, but let me show you. Now, if you had the Uverse wireless receiver, you could take this anywhere. See? Anywhere you want.
Don't settle for Uverse. Get the most entertainment on any device anywhere with Xfinity from Comcast.
Thanks, Ken, for the valuable information. We're now going to take a 10-minute break, the purpose of which is to give you one more. Good morning. I'm Julie Woodfin, Professional Development Coordinator for the Colorado Association of Realtors, and I wanted to thank you for joining us today. Ken Levinson is with us this morning to talk about ways to reduce your exposure to E&O claims. He'll bring to light the different types of E&O coverage and review some best practices. He'll also highlight some very common activities that often lead to E&O claims, and should you ever find yourself facing a claim, what steps you should take. But first, I wanted to pass along a special thank you to First American Title for their support in presenting our webcast program, which is part of our professional development initiative here at CAR. I'd like to give them just a few minutes to catch us up to speed on some of what they're working on.
Hello everyone, my name is Ben Gauze and I'm an account executive with First American Title. Before you start today's webinar, I'd like to give you some information about a change that could affect the way our industry does business. The change that I'm talking about is the CFPB in August of 2015. Now there are 4 important changes that First American Title and I would like you to be aware of. The first change is that aside from reverse mortgages, your clients will no longer receive an initial truth in lending, or TIL, a good faith estimate, GFE, or a final TIL form and HUD-1 settlement statement. The second change that you need to be aware of is that the initial TIL and GFE will be replaced with the loan estimate, and this must be provided 3 business days within the loan application. The third change is that the final TIL in HUD-1 will be replaced with the closing disclosures. These disclosures must be provided 3 days prior to loan closing. This also means that borrowers cannot close on their loan until at least 3 business days after receiving the closing disclosure. Fourth, and finally, these changes go into effect on loans on which the application is taken on or after August 1st of 2015. This is just one of the many important changes we'll be implementing in the future. Expect to hear more from us as we approach the deadline for implementation. For now, you can rest assured that First American Title is devoting time and resources to upgrading our technology and training our staff to effectively utilize the new documents once they become effective. For more information about the CFPB, visit the link on the screen below. As August 1st gets closer, we'll have courses for you to learn more about the CFPB and how this may affect your business. You can visit our class schedule at www.firstamedu.com or call me on my cell with any questions.
Thanks again to First American for your continued support. I also have just a few housekeeping items. We've allocated an hour and a half for today's presentation with a 10-minute break scheduled at about 10 o'clock. If you have any questions along the way, type those into an email and send it to profdev@coloradorealtors.com. That address is also posted there on your screen. We'll collect those questions and review them during the break and have Ken address as many as he can when we return. Now with that, I'd like to introduce Ken Levinson. Ken is an attorney at Balaban, Levinson & Costigan, PC, and focuses his practice on the defense of malpractice cases involving professionals in the insurance and real estate industries. Mr. Levinson has significant experience representing businesses, insurance carriers, homeowners associations, and banks and credit unions, as well as numerous individual clients in all types of matters, including domestic relations cases. He is currently a member of the Forms Committee of the Colorado Real Estate Commission. Mr. Levinson has participated in numerous mediations and arbitrations, and we're pleased to have him here with us today to share some of his expertise in matters of E&O claims.
Place to listen to this presentation this morning. I'm going to talk first a little bit about E&O coverage, what it is, what it isn't, things like that. Then I will talk a little bit about what happens when you have a claim, what you should do and what you shouldn't do, what it means to have a claim and how that affects your insurability and things like that. And then I'll move into errors and omissions issues that are coming up that we're seeing fairly regularly these days, a few new developments, both in terms of case law and from the Colorado Real Estate Commission. And then we'll take a little break and we'll open things up for questions. So I'm going to start by talking a little bit about what errors and omissions coverage is. It's fairly straightforward. Errors are mistakes you make. Omissions are things you neglect to do. The coverage applies essentially for real estate functions. So it's not general liability coverage. It won't protect you for car accidents, things like that. Significantly, particularly for property managers, it doesn't protect you for things like slip and fall claims, things that arise harm to persons at the property that you're managing. And so we suggest that you consider your E&O coverage in the context of your overall insurance and that you talk with your insurance producer and put together for yourself a plan that makes sense to protect all the different kinds of risks that you might face. There is limited coverage available through a few of the carriers for the slip and fall kind of liability claims for property management, but they have fairly limited coverage, and they're what's called Pac-Man coverage, meaning that as you spend defense dollars defending the claim, the limits of liability go down. So it's coverage that's available, but it's a very limited benefit. So E&O coverage will cover you for mistakes, for negligence, simple errors, things of that nature. It doesn't cover punitive damages. It doesn't cover penalties under statutes. It also doesn't cover things like fraud. So having the insurance, of course, isn't a license to just do whatever you want and figure that the insurance company will take care of the problem. So there are two kinds of general insurance that are available. What's important about the insurance for brokers is it's called claims-made coverage, and it's a timing question. Occurrence coverage is what you have through your car insurance, for example, or your homeowner's insurance. If you have coverage in effect today and the snow causes your roof to cave in, whatever policy you have now will provide the coverage, and whatever the limits are in effect today will decide the total amount that the insurance company would be responsible to pay. With claims-made coverage, which is what you see more in the professional liability types of insurance, what matters isn't what coverage was in effect on the day the incident or the mistake or the omission happens. It's what coverage you have when the claim arises. Sometimes that's the same. If you make a mistake today and somebody immediately starts making a claim against you, whatever coverage you have in effect today is the coverage that matters. But as we get to the end of the year, if you have a January 1st renewal, for example, the coverage that you have in effect next year when a claim may arise determines what coverage you have for a claim based on something you do this year. And what's significant about that is particularly if you're changing coverages, if you let your coverage lapse, which has implications, of course, with the real estate commission and all of that, but if the coverage lapsed for whatever reason, and even though you had coverage on the day the claim arose, when it's first actually presented or made, if you don't have coverage, you're not going to be covered. So it's important to keep that coverage in effect and to renew it when it comes due. What also matters is the limits of liability. I'm strongly an advocate for not just getting the minimum 100, 300,000 coverage that the commission requires. It makes it more difficult for us to defend cases if you have the lower limits. It also leaves you exposed. Unless you're selling $100,000 or less homes in some shanty town somewhere, 100,000 generally isn't enough coverage. Most claims aren't going to exceed that amount, but the claims that are the serious ones can. Claimants tend to inflate the amount of their claim, and so we can defend you better, you can sleep better if you have higher limits of coverage. I'm not an insurance salesperson, I don't get a commission, but we've found over the years it's just much better. For the cost that brokers pay for their insurance, you're really getting a good deal. I know it's aggravating to have to pay sometimes. Some people don't like having the coverage, but from an insurance perspective, it's really a bonus, a good price for the coverage. Take a little extra time, think about it, get the extra coverage. It makes a big difference. Okay, I'll get off of that. So the next issue that comes up in terms of timing for insurance coverage has to do with something called a retro date. And so every E&O policy, as I said, it's in effect for a year, for example, and any claim that arises during that year, even if it's for an incident that happened before that year, will be covered if it's not otherwise excluded for fraud or there are certain other kinds of exclusions that we'll talk about a little later. But there's one more twist to that. If you didn't have coverage last year, but you have coverage this year, you may not have coverage for a claim that's first presented this year. For one, it has to have been reported or turned in, or in some way the insurance company has to have been told about it during your renewal. Because if you're buying coverage for, say, January of 2015, you know of some matters that are potentially claims, and you don't tell the insurance company about it, they can argue that they were defrauded or misled and either wouldn't have issued the policy or might not have issued the policy. It's not as strong in the E&O coverage for brokers as some other professionals because of the way the statute's written. But you expose yourself to having no coverage, not just for the claim, but at all, if the insurance company can prove that you knew about something that was important and you didn't tell them about it. So that's one issue. The other issue is something called a retro date. And every policy says, we'll cover you for claims that arise this year, including claims for events that occurred prior to this year, but only after the retro date. Typically, if you have coverage every year like you're supposed to, and you haven't changed insurance companies, the retro date normally won't be a problem. You can have a retro date that goes back 10 years, and so, or more. And so it's not normally a problem. But if you've been changing coverage, changing carriers, then you need to really pay attention to that retro date, because if it only goes back a year and it turns out you did something 2 years ago but the claim only arises right now, you still may not have coverage. All of those are things you should look at, and the two main carriers that sell the E&O coverage in Colorado are Williams Underwriting and Rice Insurance Services. They're both easily accessible. They both have websites. Williams is WUGEO.com. Rice is RISCEO.com. And you contact them. The underwriters are nice. They'll talk to you. You don't have to just fill out the form online if you have questions. So these are issues you should think about before you have a claim, before you have any problems, because obviously it's important to have the coverage in place. The biggest thing you get from the insurance coverage is the defense costs. If you don't have the insurance for a claim, you essentially have to hire and pay for your own attorney. In many of these cases, that's the biggest problem with the case. There may not be that much in controversy being fought over, but the cost of hiring someone to defend can be significant. Okay, so we've talked about retro dates. I've mentioned a little bit about the limits of liability. The cases, if you have too little coverage, as I said, there's always your personal exposure, but it also makes the case a little harder to defend and settle, because if there's enough coverage, sometimes we fight over who's responsible and in what percentages. We fight over damages and so on. But in some cases, it comes down to, look, if we lose, we're going to lose a considerable amount, and if that amount happens to be above your above your limits of coverage, then there's a bigger press from a mediator or just from the risk itself to settle a case that otherwise we'd never even think about settling, only because the important part would be to terminate your personal liability or personal exposure separate from any insurance coverage. Okay. It also increases, well, let me back up. In all of the E&O cases, we at the beginning of the case send a letter to our clients explaining how the procedures are going to work and what's likely to happen, what they may encounter as the case proceeds. One issue we frequently mention is the ability to have their own or your own personal lawyer involved in the case, either to monitor it. Once in a while, somebody really wants their attorney to stay actively involved in the litigation itself, at their expense, unfortunately. But the point being, the more coverage you have, the more reasonable we can defend you, and the more less likely, let me put it that way, it is that you even need to consult or hire or talk to a personal attorney, because your personal exposure goes down considerably. When you are buying your coverage, There are a couple of endorsements you probably should think about. If you're a property manager, and I mention that because we're seeing a lot of property management claims these days. So if you're a property manager, there's a separate endorsement that you can and obviously should consider from the insurance companies, because it will cover your property management activities, whereas otherwise those typically won't be covered. There's also an endorsement. Well, let me start with, there's an exclusion for people who own the property that's the subject of whatever the dispute is. Typically, if you own 25% or more of the property, that transaction is going to be excluded from your coverage. So there's an endorsement that's generally available, and you should consider that, because if you're selling your own personal properties, or if you're doing a lot of fix and flips, or if you're doing any fix and flips, and you're going to be an owner or an owner of the LLC that owns the property, you might find yourself without coverage under your E&O policy. Typically, brokers who are doing fix and flips are also the broker in the transaction, and so you might find yourself without coverage. Again, so think about that endorsement. Okay. I think I've covered pretty much the basics of E&O. Most of you won't have to deal with any of those issues if you're just regularly buying your policies and complying with the commission rules requiring the insurance. You generally won't have to deal too much with those issues. So the next thing that we will talk about is, what do you do if a claim arises? And I've started with what you don't do. We in our office probably at any given time have 50-ish claims. There are 2 or 3, 4 other firms that I know of that regularly defend E&O claims. Don't know their numbers, but I imagine it's considerable, and it's comparable to what we've got. So at any given time in Colorado, there are several hundred claims pending against brokers. It's part of the cost and the risk of doing business. So if and when, well, let me put it this way. For lawyers, they tell us in a 35-year career, you're likely to have 3 claims. 2 minor ones, 1 perhaps a serious major claim. So far our firm fortunately has avoided that, but that's what they say the odds are. And so in a brokerage career of a similar length, you're apt to have a few claims. You're not going to make everybody happy all of the time, despite your best efforts. And so that's one reason you have insurance, and that's the protection and hopefully some security or comfort that it gives you. So if you do have an E&O claim, the first thing is, don't panic. The world isn't coming to an end. All of these claims have a life cycle. They come, they get dealt with, and they get resolved in some fashion. So you get to the right people and you get some help, and the matter will get taken care of. So what don't you do? You don't try to settle it on your own. And I know of cases where a broker has successfully done that. So it's not this absolute rule that you will die if you try to settle the case, but it's risky. And the big risk is that the insurance companies really don't like it when somebody who's an insured is out there trying to fix the case and get it resolved, particularly if it involves our next item, don't admit fault. If the broker starts saying, it's all my fault, I'll take care of it, I'll fix it, sometimes you get lucky and that takes care of it. But oftentimes you'll find a claimant who accelerates or exaggerates the claim and essentially just uses your own good intentions against you. So you don't want to get into this mode of there's something urgent, we've got to get it resolved this second. I'll just write somebody a big check, and particularly I'll write a check without getting a release that some lawyer has drafted or reviewed to make sure that you really are done and they don't come back for more or new claims or something like that. Okay, so these days there's also an inclination when you get the case to get a little nervous and tell everybody you know about it, chat about it online. That's always dangerous. For one, the plaintiffs or claimants' lawyers, they know how to use the internet, and they look. And they look online, and they'll say, this broker just said that it was all his or her fault, or is saying bad things about my client. And if the matter becomes litigated, you can be sure that your internet postings are going to be shown to you and thrown in your face during a trial. So be careful what you say online. Sometimes the claimant's lawyer will start saying, oh, I need a lot of information. I want a copy of your file, and I just want to talk to you. Tell me what happened. Tell me what's going on. At that point, when the other party has an attorney, or sometimes the other party or the other party's broker will call you fishing to try to get information from you, that's when you should see that there's a claim coming, there's a problem. That's the time to get help. Now, there are a couple different ways to get the help. And we'll move ahead here. Many firms have their own counsel, their own general counsel, or someone outside who they consult when problems come up. Of course, you should always talk with your own attorney. You should always get some input, find out how they think it should be handled. Sometimes they can get the matter resolved without it becoming a major problem. But the second thing is the E&O counsel. When you turn the claim in, and I will come back to what happens when you report a claim, what its implications are. The general rule, though, is going to be if something is a claim, it needs to be turned in. If it doesn't get turned in, you risk losing the coverage for that claim, you risk losing the defense costs, you risk prejudicing your own rights and the insurance company's rights by doing something that turns out to have been not a good idea. So when you turn your claim in, someone from the E&O company, most of the adjusters that we deal with are attorneys. They're not located in Colorado. The Zurich Insurance Company through Williams Underwriting, most of those people are in Illinois, and the Rice people are in Louisville, Kentucky, near the Corvette factory, I'm told, but that's a side issue. When you turn your claim in, though, you'll be talking to people who handle many, many claims. They know how these work. They can't give you legal advice, but they'll give you some input as to, okay, here's what we want to do, here's what you shouldn't do. So they'll kind of guide the procedure. Sometimes they get involved in direct negotiations with the other side or the other side's attorney. I know a lot of people think that the insurance companies are just in the business for, well, we'll settle the case, we'll write somebody a check because we don't want to have to pay defense costs. If you have an E&O claim, you quickly find out that's not how it works. The carriers take seriously their duty to investigate, to try to figure out what the case is all about, but they also very much take seriously their duty to defend. There are two duties an insurance company has in these E&O cases. One's a duty to defend the insured. The other is a duty to indemnify or pay the loss if there's a loss and if it's a covered loss. But the duty to defend is always considered to be a broader duty than the duty to indemnify. So in most cases, they're going to have to defend the case. Once in a while, you'll get a claim that's just so clearly not a brokerage issue that the carrier will say, we're not going to defend that. Otherwise, if the complaint or whatever if it's a DORA complaint, alleges things to do with your brokerage that would in some way potentially trigger coverage, they'll generally defend you. So they will sometimes try to negotiate a settlement if it's feasible and reasonable and if it's acceptable to you, because you have a right to consent to settle, which I'll also come back to. But the next thing they do is get E&O counsel involved. You, under the statute as brokers, technically and practically have the right to select your own counsel. There are some limits on that, of course. You don't necessarily want your ex-wife's husband's brother-in-law, whatever the relationship might be, if just somebody you know who you like as a lawyer. You really should consider somebody who does E&O cases, understands how they work. knows how to deal with the insurance company. You quickly learn that we E&O lawyers get a lower billing rate than other firms charge because we work so much with the carriers. Your own personal attorney may not want to reduce his or her rate to work with the carrier. So you'll have that opportunity. The carriers will often give you a list or a few names to consider, and it's good and beneficial to you to try to find an attorney who you're comfortable with, who you feel is listening to you and will defend the case the way you'd like to see it defended. We find some insureds want to fight to the death and take it to the U.S. Supreme Court if they lose. Others look at this as just a business problem. Let's get it solved, let's move on. And so there are all those different ways these cases can be handled. Okay, so in terms of as soon as you know about a claim coming, and some of these things are actually that I'm about to talk about, things you really should think about even before there are claims. For example, preserving your entire file. There's a big push in the federal courts and a little lesser degree in the Colorado state courts for electronic discovery, which means copies of not just the email, but if there's a dispute about was it sent, when was it sent, was it received. Sometimes the claimant will actually want to see the electronic, if it's Outlook, the PST version, the PST file, or whatever program you're using for your emails, they may actually want to see the electronic version of it. And so it's important that you preserve all of those records, including anything electronic that's been uploaded or is online where the contracts are now signed using the Etch-a-Sketch approach. Those things all need to be preserved in case there's any sort of dispute. And as soon as you know there's a dispute, you absolutely need to take steps to protect all of those materials. It's legion to hear brokers and pretty much everyone else say, my computer crashed, the hard drive died, and everything on it is lost. That is a problem these days in litigation that needs to be protected against. And so that gets to my next issue, which is it's really important that you back up your files. You should keep a copy preferably off-site or in some way just make sure that if something happens to your main computer, all of your materials aren't lost. Okay, so you've got a complaint. You should talk to your employing broker about it. Let him or her know what's going on. If it's a DORA complaint, there's typically 14 days to respond to the letter that you get from the division, the real estate commission. They will often give us more time if we can explain why and have a decent reason for it. So that 14 days is a short time frame. So that's when you do need to know there is generally coverage under your policy for DORA complaints. With RICE, there's a $2,500 cap, which for the initial procedures is usually more than enough. I'm not sure about Williams if there's a cap or not. I don't believe there is. But that's something you should look at your policy. But we can help provide the commission with a response. There's a tendency, unfortunately, sometimes to just write the commission and say, look, this claimant is a moron. He or she doesn't know what they're talking about. This is stupid. Dismiss the complaint. We always suggest that that's a bad idea. It takes a reasoned, rational explanation of what happened. The commission will look at not just what the issue is that's being complained about. They'll look at every issue that they see in the file. So it's important to get that done properly to make sure that you file a proper response. So that's another reason to get the insurance company involved early on. Okay, we hear a lot about I shouldn't report my claims because they'll cancel me, they'll non-renew me, they'll raise my premiums, and I'll be out of business. That can happen in many insurance contexts, but not so much in the real estate brokerage concept. Because, for example, your homeowner's coverage, you have enough hail claims, or your automobile coverage, you have enough accidents or tickets. They're going to decide you're too high a risk, They may not reinsure you, or they'll move you to a different carrier that's not a preferred carrier. They charge more, your premiums go up. Sometimes they'll say, we just don't want you anymore, go to some other carrier. The way the Real Estate Commission program is structured, RICE, which works with Continental Casualty, which is one of the CNA companies, excuse me, RICE is the program carrier. They essentially have to take everybody. So if you're buying the basic 100, 300 coverage, and I'm told if you're buying the next level up, which is the 250, 500 coverage, they will just accept you regardless of what claims you've had, as long as you're disclosing the claims when you fill out your application. They're not going to charge you any differently than they charge anybody else, and they're not going to tell you we won't insure you. Similarly with Williams Underwriting, they're working with CAR, and I saw on the website recently language to the effect that they will accept anybody and they won't decide not to cover you simply because you've had claims. So with your E&O coverage, that's not a good reason to avoid turning in a claim these days. So what you get when you report the claim is legal advice from the lawyers that are hired to defend you, some input from the adjusters themselves, and the biggest thing is you don't have to hire your own personal lawyer on your dime to defend the case, to fight with the other parties, etc. That's all provided to you. Your deductible is usually $1,000 per claim, and it does not go to attorney fees, so you would never pay us or any of the other firms any of that $1,000 deductible as your attorney fees. That solely goes if we either settle the case with your consent or we lose and pay a loss. The first $1,000 of that are yours. One of the things when the claim gets reported, when you have counsel representing you, one of the things that frequently happens is the lawyers can come in and kind of calm things down. It becomes a process and not just this urgent, we've got to do something immediately. It's now in the system and it'll get handled in the course of things. Frequently we go to mediation. Sometimes the parties just get everybody talking, and or the lawyers get everybody talking, and we try to get it resolved. So sometimes the problem can be fixed short of litigation if you get help involved soon enough before everybody just goes to their neutral corners and comes out fighting. Okay, I've talked a little bit about selecting legal counsel, and again, it's just important to get somebody who understands how these E&O claims work. You need someone who works with insurance companies, who understands their reporting requirements and those sorts of things. It's much better if there's a working together relationship with the carrier, as opposed to, we're at odds with the carrier. The carrier really will look at the case, evaluate it, and they will not just say, uh-oh, we don't want to pay money to defend, let's write somebody a check. They'll talk to you about it. And throughout the course of any E&O claim, regardless of who your attorney is, you always have the right to talk to the adjuster. They're friendly, nice people, they're easy to talk to, and if you have concerns about something that's happening or that isn't happening, you always have an ability to talk to them. So, one key point. The lawyer that's hired by the insurance company, first of all, is always a Colorado lawyer because they have to be licensed here, and they're your advocate. So if we get hired to represent you in a case, we are your attorney. We owe you the fiduciary duties that we owe any of our other clients. We work with the insurance companies. We like these companies. They're good companies. We communicate with them, but our duties are to you. And I know a lot of times we'll hear, well, the insurance company just hired their lawyer to come in and take care of them. And that just isn't the case. Whoever you hire or is hired for you in these cases is your lawyer, and you're the person that they're defending. They do have to communicate with the insurance company. We do have to provide reports to them and all of those things. But don't be concerned that the lawyers that get hired are really somehow just insurance company spokespeople, because we're not. Okay, consent to settle. A lot of times brokers will have concerns at the beginning of the case of this insurance company is just going to make me settle and they're not going to listen. That won't happen. They will listen. They will, as I say, analyze and evaluate the case. We, as your counsel, particularly in reporting to the carrier, try to give them an objective view of the case. If we're in mediation, you're going to see that we make all of our arguments to the mediator. They're very one-sided. But our reporting to the insurance company and to you is neutral. We try to give you a sense of here's where the case really is, here are the good things, here are the risks and exposures. But the carriers, having looked at all of that, normally aren't going to come to you and say, we're going to settle this case. We don't care what you say. Under the statute that created all of this, you have a right to have your opinion heard. The carrier can't settle without your consent. There are some business reasons where sometimes you do want to settle. Some people are saying, look, I need to be out there selling real estate. I don't have time to mess with this. If you can settle it for something reasonable. And for our vernacular, reasonable also includes normally confidentiality and a few other issues to make sure, A, it gets resolved, but B, it doesn't destroy your reputation, because we try to do what we can to help that. So we try to make it, the settlement, again, confidential, and nobody's going to keep talking about the case. But again, don't be concerned. The carrier isn't going to just come in from day one and say, you need to settle this case, end of story. You're not going to get pressured like that. Okay, so the time is moving on here. I'm going to move on to some of the issues that lead to claims. I want to give one caveat. What I'm talking about here is risk reduction, ways to reduce the possibility of getting into an E&O problem. This isn't the standard of care. That's an entirely different subject with different rules, parameters, and so on. So this is just things you can do to avoid claims. It's important to remember your role as a broker. We're seeing more and more claims where, well, let me do this. A broker who's an agent for any party is a limited agent. You're not the general agent for your client. You're not in charge. You're not the one who makes the decisions. We're seeing cases where sometimes the broker takes the ball and runs with it a little more than he or she should, and forgets that the principal, the seller or the buyer, is really the decision maker. So it's important to understand, your role, particularly your role as to the parties, and even more so if you're a transaction broker, because as an agent you're an advocate, you're helping, you're counseling and giving advice to the person that you represent. As a transaction broker, you have to stay neutral. There are some circumstances that we're seeing, particularly in a fix and flip. If you're the seller, you shouldn't be a transaction broker. You should just be representing the seller. And there are other situations where it's difficult to stay neutral. If you're selling the property for your parents, for example, you're going to be hard-pressed to be neutral in dealing with a buyer. And so you should consider being solely a limited seller's agent. We're seeing issues about brokers saying, parties, you are now out of contract. And I've had some relatively heated discussions about some of that. When you're in contract, you have a contract. If somebody blows a deadline and doesn't give a notice or doesn't do something they're supposed to do, even, for example, doesn't close on time, that doesn't mean you're out of contract. It means somebody may have breached the contract, which is different. And so it's really important to keep that concept in mind of the broker isn't the keeper of the contract. making legal determinations as to whether there is or isn't a contract and who's breached or hasn't breached it. All right. I'm going to move ahead to disclosure because a case came down late last year at the Colorado Court of Appeals. Excuse me. It's in re the estate of Gattis, Gattis, and that's an important case in part because it changed some of the rules that we've been either operating or under or arguing that we were operating under. Gattis was not a brokerage case. It was purely a seller of a property. The sellers had a related construction company that had done some considerable amount of remodeling and particularly structural engineering work. That was disclosed in the property disclosure, although it was only disclosed in a little one-line property, problem with foundation was repaired by engineering company. It turns out the bigger problem was that the property, as many do in Colorado, had expansive soils, and that wasn't disclosed. The case hinges on a fairly narrow legal issue that doesn't pertain to what we're talking about here today. But because of that, there were things about the case that weren't really explained by the Court of Appeals, what exactly the damages were, the difference between what soils were causing compared to the engineering work that was done. But what does matter and made the big difference in the case had to do with the seller's property disclosure. And what the court said was just filling in a little bit of information in the property disclosure form isn't necessarily sufficient to disclose excuse me, to disclose what's really wrong with the property. If it's a hidden or latent defect, it needed to be disclosed in a fairly prominent way so that the buyer understood what the buyer was getting into. And in that case, it wasn't properly disclosed. So the morals we're taking from that are, first of all, it isn't enough to just say past water leak was fixed. There needs to be a better explanation, and you don't have to use the little blanks. Those were the seller property disclosure form is geared to helping the seller remember all the things that need to be disclosed or that could possibly have gone wrong. But it isn't the end of the story, particularly under the Gattis case. If there's something that needs to be disclosed, put C attached and do an attachment and lay out exactly anything that needs to be explained or disclosed to the buyer. The fact that it was fixed or that the seller thought it had been fixed, in that case, wasn't sufficient. If you just say there was a problem and it's been fixed and you don't really disclose what the problem is so that the buyer can investigate that, you've essentially taken on the insurance yourself of if it turns out that fix wasn't a complete fix, I'm now personally as the broker going to be responsible for not disclosing that. Okay, so the other part of Gattis that was important is we have always argued that you needed to show that there really is some harm here. The buyer wouldn't have bought this property because whatever, and that's usually pretty speculative. What Gattis said is, no, the test is maybe the buyer wouldn't have bought, which opens that door pretty widely. So what it means is things need to be disclosed. They can't be minimized. We see cases where the seller at least claims, the broker told me, don't disclose that, it's not important. And what I want to emphasize this morning is, please don't tell your seller things like that. Nobody knows when they're filling out the form what's going to turn out to be important. What crack in the foundation may turn out to be evidence of something more significant. So it sounds simple, and I know people worry about losing a transaction, but it's still disclose, disclose, disclose. You really need to make sure the buyer has a good faith ability to know what's going on. We hear sometimes the caveat emptor, or let the buyer beware. In our office, caveat emptor, as a joke to us, is the Latin for punitive damages, because if you get in front of a jury and say, well, it's the buyer's problem, he should have found that, juries aren't going to go along with that, and it increases the risk of a punitive damage award, which is not generally covered by insurance. From the buyer's side, are seeing cases where the broker allegedly said, oh, there's a crack here, but don't worry about it. I see those all the time. It's small. The house has been here for 50 years. That's not a sign of any problem. Don't worry about it. That goes across the line of where you should be if you're wanting to avoid an E&O claim. You don't know what may have changed in the surrounding the land around the property, or what may be going on with the house. Again, when you tell somebody something's an easy fix, you've essentially bought that claim if something goes wrong. The presumption should be, I don't know what that is. I see it. I've seen those before. You should have an expert look at that. That's sort of the mantra that comes up in these cases. Your duty as a broker is to advise the parties to get experts about things that you're not an expert in. Okay, we're seeing a few other things come up. Every couple years, we'll see a situation where the broker accidentally gets a seller into multiple contracts. I should move forward here. It seems silly, but it really happens, and it happens with a surprising frequency. You should never have your seller submit offers or counter offers to multiple potential buyers. There's an entire law school class in contracts about when offer and acceptance have occurred, whether you need notice of acceptance. Then you get into the battle of what time did the email come in, did you see the email when it came in. It's just dangerous. There's nothing wrong with telling a series of buyers, we have a bidding war going on here, everybody submit your offer and we'll decide which one to accept. But submitting these counter offers is just a disaster waiting to happen. Those cases sometimes get real ugly because people get stubborn and they're going to fight about the property. I was here first, I want it. They get expensive too, because the broker under the listing contract is going to end up paying all of the seller's attorney fees fighting all these would-be buyers. So we're seeing this again. Please be careful about that. I'm going to jump ahead to the inspection notice issue. One of the things that I keep hearing through the forms committee, and by the way, no new contracts in January of next year. Things are going to stay the same for a little while. But one thing that is a big issue is this whole issue about the property inspection and resolution. We started seeing a lot of claims 2008, 2009, where buyers were going to closings and not only buying the property but getting considerable sums back from the carrier to fix the basement, which somehow never got fixed. Payments didn't get made, and the lender started suing everybody involved for fraud, saying, you tricked me into paying this extra money. Back in 1971, the Colorado legislature actually passed a statute. It's on our list here, CRS 18-5-208, which makes it a crime to have dual contracts. And I raise this issue because the Real Estate Commission has been very concerned, we've been hearing it through the Forms Committee, regarding this whole issue of negotiating changes to the contract and not telling the lender about it. And the position of the commission, rather, has tried to make it pretty clear you need to let the lender know about it, or at least let if you're the buyer, let your buyer know that the buyer should tell the lender about it. You don't necessarily have contact with the lender. It's not necessarily your duty to circumvent your buyer and go to his lender or her lender and say, hey, you need to know about this or that or whatever. But what the commission has done, it's a new position statement, CP 43, and I suggest that you look at it. because there's the tension between if we tell the lender about everything that this buyer is claiming is wrong with the property, the lender's going to say, well, I won't close until all these items are fixed, and now your closing isn't going to happen. But the other side of that coin is not telling the lender, hey, there's a side deal where we're going to replace the roof, or we're going to give another credit to the buyer so the buyer can, buy a new sewer line or something like that. And the commission in this position statement is making pretty clear they think that you need to do it in the contract, and it needs to be advised or provided to the lender. The inspection objection form and the resolution form have been separated out. The idea being simply because someone comes in and his or her inspector made this laundry list of everything they'd like to see happen, that doesn't mean those are defects in the property. And so disclosing those to the lender might be problematic. It might in some way taint or stigmatize the property. So the acceptance form is separate, and that has, here are the things that we are agreeing to fix. We're no longer now talking about defects in the property. We're talking about changes to the contract, and in some fashion the lender needs to be told about those, and those items become part of the contract. The Real Estate Commission is serving notice to everybody. If you do what they consider dual contracts, you could have serious licensing implications. So please be careful about that. Another issue we're seeing is the use of buzzwords. We're arguing about a case right now about a first right of refusal, which is slightly different from a right of first refusal. And the people who drafted the document just said this was a lease between a landlord and a tenant. It said buyer shall have a first right of refusal. And then when the broker came in and said, okay, let's sell this property, a dispute has arisen as to, okay, on what terms? When do you give notice to the tenant to exercise, in this case, his right of first refusal? How long does he have to exercise? When does he have to close? None of those terms were specified. And so a lot of times we'll see brokers just putting in homes, sale contingent on seller or on buyer, for example, selling his other home. That doesn't provide enough specificity to resolve any issues that are going to come up in the case. A lot of people are strongly advocating those are things that brokers need to consult a lawyer about, shouldn't be drafting for themselves. We probably won't have time to get into it today, but there's a whole series of issues arising these days about the unauthorized practice of law. So you can't use forms that you got from somebody and cob them all together using language from different people, particularly for property management leases, property management agreements and leases. There's a whole new issue emerging through the commission for using those forms. But in filling out, for example, the standard contract to buy and sell, it's important that you don't just fill in some buzzword. Your firm may have some language that they regularly use that you get from your firm's attorney, or you suggest to the parties that if it's something extraordinary, one of their attorneys should draft it. But just putting in a quick phrase that sort of a shorthand for something else, we're seeing claims based on that. The next issue I'm going to talk about, because we're seeing fewer E&O claims but more real estate commission complaints about it, to the point where the commission actually just came out with CP 36, the commission position on minimum service requirements, is the whole issue of reduced commission brokers. And there are two sides to that issue. The brokers who are reducing their commissions, you still have an obligation to provide full services, all of the services excuse me, in the statute or in the listing contract. You can't select and tell the seller, we're only going to do a few of these. The commission makes clear in this position statement they're not getting involved in the commission amount. So if you're a broker who's reducing your commissions, if your seller agrees with that, that's fine as long as you're still providing full services. And one thing we've just seen from the commission, they just did an emailed notice, I suppose, of brokers who work with builders and who are putting properties in the MLS, not getting charged, not charging for it, just as a courtesy to the builder, you put something in the MLS, and to be safe, you fill out a listing contract so you're using the commission's form. They've just served notice that they don't approve of that, and we've got a case where we're waiting to see what kind of sanctions they're going to try to impose on the broker, if any. So be careful about that. People have been doing that for a long time. It looks like the commission is serving notice that it's no longer acceptable. So going back to the reduced commission brokers, the other side of that claim is, or of that issue, is brokers who say, look, I'm not showing a property of some broker who's charging a low commission because that impacts me and I'm not going to get a commission or enough of a commission. So CP36 makes clear you can't do that. And the commission has made it clear in matters that we've been involved with that they're not going to be happy about that. Because as the buyer side, particularly if you're a buyer's agent, your duty is to your buyer to try to find them a property, not to just do something to get yourself your own commission. You can, of course, in an exclusive right to buy contract, lay out how the commission gets paid, and if it's under a certain amount, the commission is saying we're not getting involved in the numbers or percentages. You can certainly say the buyer will pay X dollars or X part of the commission if I get less than that from the seller. And then it leaves it to the parties to negotiate out how that works. But the moral of that is don't just say I'm not going to show properties of these brokers if I disapprove of them. It's going to get you in trouble. One new thing that's not on our PowerPoint is coming soon listings. CP44 came down June 3rd of 2014. And the commission in that regard is saying they're not prohibiting it. And again, these are commission position statements, which means they don't have the force of law as though they were rules or regulations. But they're a pretty good sign of what the commission is going to do if a complaint comes before the commission. And what they're saying is listing brokers, they don't want you to hold the property off the market to try to double-side the deal, find your own buyer, because that could be to the detriment of the seller. So if you're going to do that, you need to talk to the seller, explain what you're doing, why you're doing it. The theory is if it's exposed to the broader market, the property may bring more money or more benefits to the seller, and therefore you may be, excuse me, as a seller's agent who owes fiduciary duties to the seller, you may be breaching those duties if you're putting your own interests above the interest of your seller. So if you're doing that kind of the coming soon listings, you should really look at CP44. All right. Another issue or things that we're seeing that are contributing to claims have to do with marketing and social media. And I sort of joke that you are what you upload. If you're telling the world you're the best broker on the planet, you'll get them the best deal ever, you know if there's a claim and something goes wrong, Exhibit A at that trial is going to be the claimant's attorney saying, well, look, you advertise, you promised my client all these things, right? So got to be careful what you put on your website. And you also should be careful about things you say in the public media. You're a professional, and once in a while we'll see somebody who gets heavily into political issues or something like that. And of course you have the absolute right to do that, but be aware that if there's a dispute, something like that may show up as a trial exhibit and maybe used to try to bias you or bias the jury to saying this is a bad person. So all the opinions you put up, particularly during a dispute, if you put up any opinions about the opposing side, all of those may come back to haunt you, because oftentimes any opinion you express, there are people out there who disagree with them. The other side of that is emails. Some things that we're seeing in cases have to do with disputes among the brokers. Sometimes you get a transaction with a broker who's just very difficult, or isn't on top of his or her game, isn't paying attention to things, isn't getting deadlines met. Be really careful what you say in emails. These days, the first thing that we go through in the case after the transaction documents themselves is all the emails. And most of the time they're very professional. We disagree. Will you do this? Can we do that? They're pretty professional and they're fine. Every once in a while we see name calling. We'll see a broker telling for example, the listing broker telling the seller, this buyer's an idiot, this buyer's a thief, this buyer's whatever. If there's a lawsuit, all of that is going to be produced. And you just have to think about how that's going to look for you as a professional, trying to persuade a judge or a jury that you were doing a good job and you didn't breach any duties to the parties you were working with. I think we're getting close to taking a break here. Let me pull up one other. We're seeing issues in fix and flips. If you're doing fix and flips, I strongly suggest that you comply with the building codes. If you're remodeling the property and you're moving walls or adding electrical or changing the plumbing, get building permits. There are people who are just, as a routine procedure, don't do that, and you start out looking very bad if there's a dispute when we get in front of a jury. And particularly, you're wearing two hats when you're doing fix and flips. If you're the seller, and so you owe duties of disclosure. You arguably, and there's no law yet expressly saying this, but we're seeing plaintiffs' attorneys saying you fall under the construction defects statute and you owe all of these duties and warranties and can be liable as a construction professional even if you weren't the person actually doing the work. And it goes back to the Gaddis case. Things that you see or observe, find, and fix when you're doing your fix and flip, those all need to be disclosed. Those implicate you as the seller, but also as the broker, because once you know an adverse material fact, you're obligated to disclose that to the other side. So we're seeing a lot of problems with fix and flips where the work wasn't done well. I always suggest if you're doing a fix and flip, don't just market what you've done to the property. In the disclosure or somewhere, make sure the buyer knows what you haven't done. If you've put in all new plumbing fixtures, that's fine. But if it's a 70-year-old house and you haven't touched any of the pipes, if you tell the buyer that, they now don't have an expectation that they have all new plumbing. And if something goes wrong with those pipes and the walls, they're not going to be able to come to you and say, hey, you defrauded me. You said it was all new plumbing. I was going to talk about property management just a little bit. We are seeing a lot of problems with owners saying the landlord, and there's an issue there. I'm going to stop for a second because frequently we see leases where the property manager is also the landlord, even though the property manager isn't the owner of the property. I'm always skeptical of that. I know there are property managers who feel you should do it that way because then you're dealing directly with the tenant. It keeps your owner out of it. The tenant isn't bothering your owner, etc. But if you do that, you essentially become the owner. You are responsible for complying with the lease. you're responsible for getting the damage deposit back on time, and if you don't, you could be subject to the triple damage and attorney fee penalty. And then also there's the issue of liability. If somebody slips and falls on the property, are you in control? Are you now the person who gets sued for that? So I personally recommend that you let your owner be the be the landlord, and you sign and prepare the lease as the owner's agent, and that all be disclosed to the buyer, or to the tenant, excuse me. In that context, we are seeing some personal injury types of claims where the property manager is getting sued for somebody getting injured on the property, somebody getting bitten by a dog on the property. One suggestion to deal with that is to get yourself added as a named insured under your owner's policy, the policy of the landowner or your client, so that you have that sort of general liability protection for things that happen to the property. You should talk to your insurance agent or the owner's insurance agent to make sure that named insured, because that means different things in different policies. Sometimes you're just an additional insured, which is typically less coverage. But those are things that you should also think about that will help you not necessarily avoid a claim, but if something comes up and there is a claim, that's something you can use for protection. It looks like we do have some time to talk about the unauthorized practice of law. That seems to be a growing issue also. Property managers, well, I believe the F rules, there seems to be a process underway. I'm not involved with it, but I'm generally aware that there's some discussions about changing some of the F rules that the Commission has, which deal primarily with forms. It's a little unclear as to which forms you have to use when, and particularly when you can use forms that you haven't prepared. We're though seeing cases where, for example, property managers have their standard lease form that they use, and there is no Real Estate Commission approved lease form, so you're not going to get in trouble for not using the Commission's form. But we see a lot of times where somebody has cobbled together, again, a form that they gathered from 4 different law firms and saw someone else's form and put some language in there. Sometimes they're inconsistent, sometimes they're confusing. But when it's a contract that you as the broker are not a party to, so if it's a contract between your owner and the tenant, it needs to be prepared by an attorney. Practically speaking, you're less likely to get sued because it'll be a document that's presumably not ambiguous or confusing. But also you can get in trouble with the Commission for simply not, or for having used a contract that wasn't prepared by an attorney. The property management agreement, there's also no Commission form for that. So you can use your own form. There's a hint in the rules that you should have an attorney prepare it. Technically speaking, any 2 sets of parties can agree to something on the back of an envelope and don't have to have lawyers. But first of all, you ought to have your attorney look at your form, your management agreement. Make sure you're complying with the Commission rules, because they do require either the addendum that the Commission has or the, I've forgotten what the other form is. There are 2 forms that the Commission has for property management that are kind of mutually exclusive. So that's an issue that we're seeing is how the forms are being handled. I think, well, the other aspect, again, of the unauthorized practice of law has to do with when you, excuse me, when you're drafting these forms, addenda, when you're drafting additional provisions, things like that, there's a theory that if you act like a lawyer, you essentially become held to a standard of care of a lawyer to draft the language the way a lawyer would have. The way to avoid that is to suggest, and you know, it's in the contract, but it isn't enough. You really should make sure the party that you're working with knows that he or she can and should consult a lawyer. And so if you're drafting language, the kind that I talked about earlier with buzzwords, or you're just drafting language that's not the simple filling in the CBS contract, for example, you really ought to suggest to the parties that they have their lawyers draft it, or that they look at have their lawyers look at it and approve it. One issue we're seeing, for example, has to do with mineral rights and water rights. And those, if you're going to be doing anything with those, you really need to have a lawyer look at it, draft the language, because we are seeing claims about that. And it looks like we're running out of time, and I think we need to turn it back over to Julie.
Thanks, Ken, for the valuable information. We're now going to take a 10-minute break, the purpose of which is to give you one more opportunity to send us any questions you may have. When we return, Ken will address as many as time will allow. We'll see you in about 10 minutes.
The first thing is the people. Obviously, this business is about the connections you make and the people you trust. And the most important people that I trust in this industry are at this company.
The new beginning. Other companies are doing things the same way they've always done them. And so having a new opportunity to do things a different way is what really intrigued me.
I'd say from a sales perspective, what I love most is that we have really the best of both worlds. So we're a big multi-billion-dollar international company with great financials, but on the other side, we also feel very much like the small little family-run company.
I like the safety of First American, but they've got a human side to them, you know, a little softer, gentler approach, and I really appreciate that, and they've really given me a great opportunity to go out and try and build something for them.
In Colorado, guess what? We're all local. There's 4 local underwriters, and together the other day we have almost 125 years of local underwriting experience in Colorado. And I tell that to people all the time, and that's really the big difference. We can make local decisions quickly to get that deal to the closing table. That's the big difference.
We're a team, and we support each other and look out for each other, and it really promotes more business for us.
First American is all about a work-life balance, and the leadership is incredible because they truly care about the customers or the associates that work here.
This is our customer service department, and the marketing support services that are just completely robust. Marketing is a challenge for a lot of real estate brokers. It's something they have to do, but it takes a lot of time. It can be expensive, and we have a fulfillment solution that is far and away better than anything else that our competitors have to offer.
The leadership is very down to earth, and they move very quickly. So anytime I've needed something or had to support a customer or had to make a decision that maybe cost the company money or whatever, they're very quick to make a decision on that stuff.
You're working with people who have been in this market, in the Colorado market, for 30 plus years. At one point, First American was underwriting almost 70% of all transactions in Colorado, and some of those very people were working on those files.
I really believe our people are passionate about our company and do it better.
Who wants more peas?
Go away.
Oh, Daddy hates pop-up ads. Who wants
Go
more?
away.
Hashtag dinner time.
Scroll forward.
Choose selfie. No. Selfie.
Go forward.
Delete selfie.
Go away.
Send picture.
Bookmark. Go away.
No, post photo.
Scroll up. Scroll forward.
Hashtag gravy.
Faster. Go faster.
The First Bank mobile app. Technology has never been so easy.
What if there was no car legal hotline? Just one call to a lawyer would cost you at least $250 per hour. What if you only had unreliable or hard to understand industry reports to include in your business plans and share with your consumers? What if there was not an organized association to fight for your right to conduct business in a fair and equitable manner and to protect consumers' private property rights? What if CAR never changes with the times to meet our members' needs? You don't have to ask what if anymore, because over the last 18 months, CAR expanded the legal hotline 2 more hours a week to help answer your legal questions. CAR created a research program that provides Colorado realtors with accurate and reliable quarterly housing market reports. CAR successfully advocates on Capitol Hill each year on behalf of all Colorado realtors and private property owners, so you can focus on your business. CAR created a professional development program that focuses on timely and relevant real estate issues through our live webcast program. CAR established relationships with many real estate-related companies to give you member discounts on things you actually use and need to be successful. CAR produced phenomenal networking and professional development opportunities in 2013 through its meetings and events. CAR's quest to make your state association better, stronger, more relevant, and able to withstand future challenges of the real estate industry is a never-ending journey. We have successfully put many solid processes, programs, and services in place. Now it's time to take the next steps of our journey by adding more value to your membership. Our vision is to create more opportunities for Colorado realtors to lower their risk by expanding the hours of the CAR Legal Hotline. Provide more reliable industry and consumer data to make you more confident and productive in the sales process. Produce even more live webcasts you can apply to your ever-changing business and help you remain on top of your game. Build a deeper political war chest to help preserve the industry and protect your consumers' rights. Increase our outreach to our local realtor associations, MLSs, and members. Take advantage of your CAR benefits and features. Visit coloradorealtors.com for details.
And with Uverse, you can move your TV anywhere in the house.
We're happy with Xfinity. Why would we move the TV?
I don't know, but let me show you. Now, if you had the Uverse wireless receiver, you could take this anywhere.
See? Anywhere you want.
Don't settle for Uverse. Get the most entertainment on any device anywhere with Xfinity from Comcast.
The first thing is the people. Obviously, this business is about the connections you make and the people you trust. And the most important people that I trust in this industry are at this company.
The new beginning. Other companies are doing things the same way they've always done them. And so having a new opportunity to do things a different way is what really intrigued me.
I'd say from a sales perspective, what I love most is that we have really the best of both worlds. So we're a big multi-billion-dollar international company with great financials, but on the other side, we also feel very much like the small little family-run company.
I like the safety of First American, but they've got a human side to them, you know, a little softer, gentler approach, and I really appreciate that, and they've really given me a great opportunity to go out and try and build something for them.
In Colorado, guess what? We're all local. There's 4 local underwriters, and together the other day we have almost 125 years of local underwriting experience in Colorado. And I tell that to people all the time, and that's really the big difference. We can make local decisions quickly to get that deal to the closing table. That's the big difference.
We're a team, and we support each other and look out for each other, and it really promotes more business for us.
First American is all about a work-life balance, and the leadership is incredible because they truly care about the customers or the associates that work here.
This is our customer service department, and the marketing support services that are just completely robust. Marketing is a challenge for a lot of real estate brokers. It's something they have to do, but it takes a lot of time. It can be expensive, and we have a fulfillment solution that is far and away better than anything else that our competitors have to offer.
The leadership is very down to earth, and they move very quickly. So anytime I've needed something or had to support a customer or had to make a decision that maybe cost the company money or whatever, they're very quick to make a decision on that stuff.
You're working with people who have been in this market, in the Colorado market, for 30 plus years. At one point, First American was underwriting almost 70% of all transactions in Colorado, and some of those very people were working on those files.
I really believe our people are passionate about our company and do it better.
We're back, and I'm pleased to report that we didn't put everybody to sleep this morning because we got some questions in, which I will address, and then we'll do a little bit of summation and we'll be done. One question has to do with the whole discussion about the seller not having to close unless and until the seller finds another property. And the question has to do with whether you can put in some sort of deadline. And not only can you, but you should. In other words, you don't want the buyer out there saying, well, how will I ever know when that contingency is triggered? What is the deadline for the seller to find another house? And is it a question of the seller has to be under contract, or does the seller have to close? So all of those issues need to be addressed. And that's one reason to talk with your firm's lawyer about not just a one-sentence thing, but some detail. It can be structured essentially similar to the way the other aspects of the contract are formed, which is you have a deadline, and by that deadline you have to give notice. And so you could say that the seller has to have the property either under contract or closed by a certain date, or that can be waived if the seller doesn't give a notice of termination. So all of those concepts are feasible. They just have to be done carefully. Someone else asked what we mean by a dual contract. And unfortunately, the statute, as I recall, I didn't go back and look at it for this presentation. I don't remember it specifically defining what a dual contract is. But on a generic basis, contracts can be verbal and they can be written. A contract to sell real estate has to be in writing to be enforceable. There are some exceptions to that, but the general rule is it has to be in writing. But a separate contract for we're going to put a new roof on and we're going to delay it until after closing, that doesn't necessarily have to be in writing. So the safest approach to that issue would be any sort of side deals need to be put in writing and they need to be disclosed to the lender. Okay. So the takeaway, a few things. One of the things that we did get a question on is, what is the bottom line? What should we be thinking about here? So the first thing is, don't be afraid to turn in a claim. There's no jeopardy and no penalty for turning in a claim. If you fail to turn in the claim, you can lose coverage for the claim. In theory, you could lose coverage for your entire policy if it happened during a time when you filled out that application and didn't disclose the claim. So there's really no downside to reporting a claim. You don't want to report every time anybody's angry or complains or something like that. But anything that looks like it's going to become a problem, you're not going to go wrong by reporting it. In terms of avoiding E&O claims, so the first thing is to remember what your role is as a broker, to remember that you're an agent, you're not the principal, so you're not the great decider, as they say, you're not the decision maker. You give advice and counsel and you guide the process, but you're not the person who should be saying what's a defect in the property, what isn't a defect. Those should all be decided by the buyer and the seller. You need to be transparent, particularly in the light of the case, the Gaddis case that came down last year. If there's something you know about, it needs to be disclosed. And it needs to be disclosed meaningfully, in a way that if you're on the seller side, the buyer understands there is a potential problem and now the buyer has enough information to decide whether to worry about it, to investigate or not. Similarly, if you're on the buyer's side, when you hear about something from the seller, it's a good idea to make sure your buyer really listens and understands and hears that there may be a potential problem and that the buyer can and should investigate that. We're seeing more DORA complaints than lawsuits at the moment. We're still seeing lawsuits, but the number of DORA complaints is going up. Those have to do less with, well, disclosure is still a bottom line issue. And if you're not disclosing an adverse material fact that you know about, you've got jeopardy both in the civil lawsuit and before the Real Estate Commission. But what we're seeing with the Real Estate Commission, we're seeing that they're being more assertive with property managers in terms of auditing the books, making sure your money's where it's supposed to be, that your records are where they're supposed to be. We're seeing some of these different issues, not so much the disclosure issues, but issues coming out of some of those position statements having to do with dealing with other brokers and dealing with your seller in terms of the coming soon listings, things like that. So there's not one thing right now that we're seeing that's predominating. Generally speaking, the best thing we can think of, or I can suggest to avoid claims, is to communicate. And you probably hear this all the time, but it's important to communicate with the other broker, to really engage and not to just get into these email battles, or it used to be phone battles, leaving messages for each other, to try to work problems out when they come up, try to avoid problems before they happen, to just stay professional. When you do have an E&O claim, one of the bottom line determinations made by a jury or a judge is how professional did this person act? Did he or she do his or her job? Did he communicate? Was he clear, or was she clear about what she was doing? Was she taking care of the best interest of the party that she was working with? Because underlying all of these cases is just that. What were you trying to accomplish? Were you trying to sell this property and dump it on a hapless buyer without full disclosure, in which case you're going to have a problem? Were you diligent about working for your client and getting the best deal you could if you're an agent, or being neutral and making sure everybody was aware of what was going on and had equal opportunity to investigate and all of those sorts of things? So the paper trail that you leave is going to be a big determining factor in how any E&O case comes out. Otherwise, I think what I would tell you is sell a lot of real estate, have fun with what you're doing, because it's a career, a profession, and not just a job. What we always tell clients, if you do get an E&O claim, the best revenge against that bad, nasty claimant is to go out and sell a lot of real estate. And that's all I have to say. Thank you. We'll turn it back to Julie.
Ken, thanks again for taking the time to be with us this morning. And thank you all for joining us today. We do hope you found today's presentation to be helpful.
All right.
Please be sure and check out the webcast schedule for upcoming events by visiting www.coloradorealtors.com. That's it from here. Stay warm and enjoy the rest of your day.
Who wants more peas?
Go away.
Oh, Daddy hates pop-up ads.
Go away.
Hashtag dinner time.
Scroll forward.
Choose selfie. No. Selfie.
Go forward.
Delete selfie.
Go away.
Send picture.
Bookmark. Go away.
No. Post photo.
Scroll up. Scroll forward.
Hashtag gravy.
The First Bank mobile app. Technology has never been so easy.
And with Uverse, you can move your TV anywhere in the house.
We're happy with Xfinity. Why would we move the TV?
I don't know, but let me show you. Now, if you had the Uverse wireless receiver, you could take this anywhere.
See? Anywhere you want.
Don't settle for Uverse. Get the most entertainment on any device anywhere with Xfinity from Comcast.
The first thing is the people. Obviously, this business is about the connections you make and the people you trust. And the most important people that I trust in this industry are at this company.
The new beginning. Other companies are doing things the same way they've always done them. And so having a new opportunity to do things a different way is what really intrigued me.
I'd say from a sales perspective, what I love most is that we have really the best of both worlds. So we're a big multi-billion-dollar international company with great financials, but on the other side, we also feel very much like the small little family-run company.
I like the safety of First American, but they've got a human side to them, you know, a little softer, gentler approach, and I really appreciate that, and they've really given me a great opportunity to go out and try and build something for them.
Colorado, guess what? We're all local. There's 4 local underwriters, and together the other day we have in almost 125 years of local underwriting experience in Colorado. And I tell that to people all the time, and that's really the big difference. We can make local decisions quickly to get that deal to the closing table. That's the big difference.
We're a team, and we support each other and look out for each other, and it really promotes more business for us.
First American is all about a work-life balance, and the leadership is incredible because they truly care about the customers or the associates that work here.
This is our customer service department, and the marketing support services that are just completely robust. Marketing is a challenge for a lot of real estate brokers. It's something they have to do, but it takes a lot of time. It can be expensive, and we have a fulfillment solution that is far and away better than anything else that our competitors have to offer.
The leadership is very down to earth, and they move very quickly. So anytime I've needed something or had to support a customer or had to make a decision that maybe cost the company money or whatever, they're very quick to make a decision on that stuff.
You're working with people who have been in this market, in the Colorado market, for 30 plus years. At one point, First American was underwriting almost 70% of all transactions in Colorado, and some of those very people were working on those files.
I really believe our people are passionate about our company and do it better.